3. Life insurance, accident and sickness insurance, and annuity claims payment of proceeds. 3.1 Rules pertaining to claims and payment of benefits. When a life insurance policy matures, or when the life insured dies, a claimant must satisfy certain requirements for the insurer to pay the benefit. The claimant must black small square provide satisfactory evidence that the life insured has died. Black small square prove their entitlement to claim the benefit. The role of the agent in the claims process will depend on the insurance company or companies involved. No claims process is identical and the agent must therefore be familiar with the claims process for the different insurers. The purpose of this chapter is to summarize the claims process and make agents aware of the pitfalls of the claims process. If the agent has not asked all the correct questions and gathered all the correct information in the application process, then the claim could be contestable. An agent will want to avoid this taking place. 3.1.1 Claimant. The claimant may be the insured's estate, or one or more designated beneficiaries, either a primary or contingent beneficiary. An assignee of the insurance policy or the death benefit may also make a claim to the insurer. It is possible for a creditor to make a claim under specific situations. A court order may allow an individual to claim the insurance benefit, for example where money is owed for spousal or child support. The insurer must take care that any benefits payable are made to the estate or to the beneficiary or beneficiaries. In the event of a dispute, the insurer may pay the benefit into court. 168 More detail on payment into court can be found later in this chapter. 3.1.2 Insurer's records. Policyholders are encouraged to consider making a beneficiary designation and to file it with their insurer. Where a designation is not filed with the insurer, it can still be valid against a person other than the insurer, with the exception of making an irrevocable designation. Insurers will pay benefits based on the most recent beneficiary designation they have on file, or to the estate if there is no beneficiary designation. The insurers are protected when they do so. 169. As discussed in the previous chapter, designations may also be found in a policyholder's will. Where this has occurred, the most recent beneficiary or beneficiaries filed with the insurer may not be the claimant. 170. 3.1.3 Notice of claim. When the insured person dies, the insurer usually receives notice of death from the agent, the estate executor or trustee, a beneficiary, or the employer. The insurer often relies on the agent to locate the named beneficiary and help them complete the claim form. Many agents know who the named beneficiary is because the beneficiary is often one of the policyholder's family member, or a known friend, business partner, or charity. But sometimes it is a challenge to locate beneficiaries if there is little or no information about them. Sometimes the insurer and the agent have had little contact with the policyholder and do not know about a death or, if made aware of the insured person's death, do not know how to contact the beneficiary. The beneficiary may not be aware he is the beneficiary. If the insured person is also the policyholder, on his death, his executors and family members may only learn about the existence of a life insurance policy when sorting through the deceased's papers. It is rare but possible that the insurer that issued the policy is no longer carrying on business, and a search must be made to determine which insurer took over that insurer's business policies. CIWM is a useful resource in these circumstances. Upon receiving a reliable notice of death, the insurer will record it, so no more premiums are charged, and will wait to receive a claim. The insurer is not required to notify the beneficiaries upon death, but the insurer will contact the agent if the deceased used one. A life insurance policy may set out a time limit in which a claim must be made. But provincial and territorial insurance and limitation period legislation govern when a person makes a claim after the deadline indicated in the insurance policy. This legislation varies depending on the province or territory. Some insurance policies indicate the applicable statutory time limits for making a claim and the proof of loss that must be submitted. 171. However, courts may be inclined to grant the beneficiary or the estate executor some relief from the limits under an insurance policy where it appears fair to do so. 172. This is a different matter from the general running of limitation periods to commence litigation, including litigation to claim a benefit denied by an insurer. 173. In some jurisdictions, some type of benefits may become unclaimed property, and the insurer may be required to remit those benefits to the government. 174. 3.1.4 Proof of claim. The agent's role in the proof of a claim is an important one. Much of the information needed to prove the claim must concur with the information gathered by the agent during the application process. 3.1.4.1 Documents required. A beneficiary must complete a claim form. Agents can obtain the claim forms from the insurer. A beneficiary, the estate executor or the estate trustee may also obtain the form directly from the insurer. Once the insurer receives the completed form with the information it requires, it will assess whether a claim is payable and, if payable, pay the person making the claim if that person is entitled to it. To satisfy the terms of a life policy, a claimant will need to establish that the identity of the person who died is the same as the life insured under the policy. They will need to provide proof. Black small square that the insured person has died. Black small square of the insured person's age. Black small square that claimant has a right to receive the benefit. Black small square of the claimant's name, age, and identity. Death is usually confirmed with a funeral director's declaration of death or a provincial death certificate. If the insured person died in suspicious circumstances, the insurer may require more evidence. For example, if an insured person died overseas in a country where proof of death is questionable, there may be more evidence needed. 3.1.4.2 Probate. While insurers do not require probate in all cases 175, they must receive sufficient evidence of the party's right to receive payment. 3.1.4.3 Proof of age. Proof of age is usually established when applying for insurance, and premiums are usually adjusted based on the true age of the life insured. If the age was satisfactorily established by the agent when the policy was issued or while the life insured was still alive, the insurer will use age indicated in the file when a claim is made, without requiring proof. Note that for term coverage, proof of a life insured's age may be critical since the insurance policy states that coverage expires at a certain age. 3.1.4.4 Proof of identity. Where there is a named beneficiary, the insurer will seek satisfactory proof of identity. For example, individuals with common names might face additional hurdles to establish their entitlement. A beneficiary who has changed her name, for example following marriage, will have to provide appropriate documentation. Beneficiaries are sometimes described in terms of a relationship, such as children, and sometimes a representative status, example court-appointed trustee, executor, and guardian of minors' property. These claimants will have to establish their qualification by means of additional documentary evidence, e.g. verification by a third party, possibly the agent, or a copy of a court order appointing them. 3.1.4.5 Accidental versus natural causes. Most life insurance policies have very few restrictions or limitations about the cause of death. However, if they do have limitations and restrictions, then the insurer or the agent may investigate to determine if they apply or not. One typical limitation is suicide. If a policy states that the death benefit is not payable when death is caused by or related to suicide within a set period of time, often 2 years of the policy being continuously in force or after reinstatement, the insurer may require more detailed proof of death to rule out or confirm suicide. The insurer may also require additional proof of death if the policy has specific exclusions for certain events. For example, a policy may have an exclusion if death is associated with an activity like scuba diving or heli skiing. Other policies may only pay when death is associated with an accident. These are called accidental death policies. The insurer will need to receive proof that death was associated with an accident and not excluded under the exclusions in those policies. In such cases, the insurer may require a more detailed physician's statement of death, or even a coroner's autopsy or toxicology report. Policies that provide an additional benefit where the death is an accident typically require that for the death to be accidental it must be occasioned solely through violent, external, and accidental means. It has also been examined by courts and has evolved through case law to have a rather different meaning than simply motor vehicle accidents, drowning and the likes. For example, the Ontario Court of Appeal had to determine if accidental benefits should be paid to an insured who was bitten by a mosquito carrying the West Nile virus and became a paraplegic. 176 The court considered it an accident as defined by the insurance policy and allowed the insured to obtain compensation. Example: Lucie was pronounced dead at the scene of a serious motorcycle accident. Forensic and witness evidence gathered at the scene established that his vehicle had very gradually veered to the right, but traveled at the same speed until collision, with no evidence of braking or turning. The coroner ordered an autopsy because his death was unexplained and apparently an accident. Suicide was ruled out and it was determined that Lucie died of natural causes because he suffered a sudden, massive heart attack while driving. He therefore died before the motorcycle accident. His life insurance paid a benefit, but his beneficiary was not entitled to the additional accidental death benefit. 3.2 Disappearance and presumption of death. Although it does not happen often, insured persons sometimes go missing. If they have disappeared and remain missing for 7 years or more, 177 interested parties, most often the family, can ask a court to declare them dead, and upon an application filed by an interested person, i.e. a beneficiary, a court may make an order declaring that such person has died. They usually do this to obtain life insurance proceeds. The timing of the death is important to establish. If a policy has lapsed due to non-payment of premium since the insured person disappeared, the insurer will require proof that the insured person's death occurred while the policy was in force. Example: Mtre was flying to Europe on holiday. Her plane was destroyed by an explosion 35,000 feet in the air over the Atlantic and very little was recoverable by search teams. Unfortunately, there was no trace of Mtre. However, the airline's records confirmed that she had cleared the gate and boarded the plane. A judge had no difficulty concluding that Mtre died the day the plane crash occurred. Since she was declared dead by a court, her life insurance policy benefit became payable as of the date of the plane crash. 3.2.1 Death of 2 or more people. Where 2 or more people pass away, the time and sequence of deaths may also be important in order to establish who may be entitled to the insurance proceeds. Joint life insurance policies insure more than one person and pay upon the death of either the first or the second insured person. 178 If the joint insured persons die in an accident where it is not possible to prove who died first or last, the policy may state who is presumed to have died first. This may also arise when it is necessary to determine whether a beneficiary outlived or predeceased the life insured. 179. Example. Peter was staying over at his mother Magda's house. They had separate rooms on the second floor. In the middle of the night, the furnace malfunctioned, filling the house with carbon monoxide. In the morning, both Peter and Magda were found dead in their beds. Based on medical testimony at the inquest, the judge was able to conclude that Peter, although younger, had probably died first, as he was a smoker and had respiratory problems, leading to more rapid breathing than his mother, who was fit and healthy despite her age. Peter and his sister were joint beneficiaries of Magda's life insurance. Since he predeceased Magda, his sister inherited the entire death benefit. If Peter had been found to have outlived his mother, he would have been entitled to his half share of her insurance, which would have been dealt with through his estate. 3.3 Payment into court. In cases like the example above, the insurer may have no need to dispute that the insurance benefit is payable, since there is conclusive evidence that the life insured has died. However, the insurer may have trouble determining who the beneficiaries are. In such cases, a provision in provincial and territorial insurance legislation allows the insurer to pay the benefit into court. 180 This releases the insurer from liability, and allows for the resolution of the conflicting claims to be dealt with by a system designed to deal with reviewing evidence and claims adjudication. Dealt with by a system designed to deal with reviewing evidence and claims adjudication. Where money is payable to a minor, as discussed in Chapter 2, some provincial statutes may require payment into court to protect the minor's funds. 181. 3.4 Proceeds on deposit and payout options. Life insurance policies may provide several options for the payment of a death benefit. These are usually referred to as policy settlement options, and the same form that the beneficiary claimant is asked to complete in order to establish their right to the death benefit may also ask them which payment option they prefer to receive. Agents are often involved in giving clients advice in this regard, but it is also common for the insurer to be instructed to send the check to the estate lawyer, the estate executor, or the beneficiaries. One of these individuals or their legal representative will have complete control over the disposition of the benefit. 182. The discussion on such payout options does not apply to retirement products, which may be subject to specific transfer or payout rules which require that amounts be transferred to specific retirement products. Insurers who transfer any amounts which are locked in for retirement purposes must limit transfer options to those entitled under applicable legislation. Agents should be aware of such payout option limitations to be able to guide clients effectively. The most common settlement option is for the insurer to issue a lump sum check to the named beneficiary or to the estate executor, who may deposit the funds with whichever financial institution the beneficiary or the estate executor prefers. 3.5 Time to pay claim. The insurer is obligated by provincial and territorial insurance law to pay a claim within 30 days of receiving evidence that satisfies that the claim is payable. 183. While under the terms of the policy there is no entitlement to interest on an unpaid claim, in practice many insurers pay interest for at least some of the time after death and before the benefit is paid. The death benefit under a segregated fund, individual variable insurance contract, IVIC, must be calculated after death. The death benefits under these contracts can go up or down in value, depending on market performance and other variable factors. 3.6 Denial of claim. As discussed previously in Chapter 2, there are at least 3 reasons why an insurer may refuse to pay a death benefit claim, in addition to the absence of coverage of the risk under the policy, including the exclusions clauses, even to a properly identified beneficiary. These reasons are black small square fraud, or more accurately, insurance fraud. Black small square payment of a death benefit which is against public order. Black small square lapse, default of payment, of the insurance policy. During the application process, the agent must check the information provided by the applicant for any possible fraudulent information. A fourth motive could be that the claim was not made in a timely fashion according to applicable provincial legislation. In that case, an insurer could invoke the limitation period. 184. 3.6.1 Payment contrary to public order. When a beneficiary causes the death of the life insured, it is considered a violation of community standards or public order, enabling the insurer to refuse payment. Note that it does not matter if the beneficiary intended to enrich themselves through the death of the life insured, such beneficiary might not even know they were a beneficiary. However, since it would be unfair to allow them to benefit from their wrongdoing, the insurer is entitled by law not to perform its obligations under the insurance contract. 185. Amit and Mary have been dating for 2 years when Amit decides to purchase life insurance on Mary's life. After a bitter argument, Amit pushes Mary off a cliff and Mary does not survive the fall. Amit is found guilty of first-degree murder and the insurer is entitled not to pay any benefits to Amit as such payments would be contrary to public order. 3.7 Accident and sickness claims. There are different benefits payable under accident and sickness policies. The claims could be for accidental injury or dismemberment or for accidental death, disability, or critical illness. Generally, for certain accidental injuries, it can be difficult to gather the information to submit a claim if the insured person is too injured to fill out the claim form. To help protect the insured person in this type of situation, there are provisions in provincial and territorial insurance law that give relief for imperfect compliance with the claims process. 3.7.1 Accident, Death and Dismemberment Claims. Under an accidental death and dismemberment coverage, a policyholder can name a beneficiary. 186 For accidental injury that causes loss, for example, of use of limbs, the payment usually goes to the policyholder who is usually also the insured person. For loss of life due to accident, the payment usually goes to a named beneficiary or, if none, to the policyholder or their estate. 3.7.1.1 Documents required. Similar to life insurance, the insurer will provide the insured with the necessary forms required to support a claim. Detailed medical evidence from a physician may be necessary to substantiate a claim. 3.7.2 Disability claims. The inability to work full-time or to continue in the same job may be caused by an accident or illness. It is also commonly caused by mental or psychological conditions, such as depression or anxiety. Short or long-term individual or group disability insurance can help protect against the risk of being unable to work. The claimant must satisfy the insurer that they meet the definition of disability set out in the policy. The disability may be caused by accident or illness. Disability insurance is not unemployment insurance. Being unable to find a job is not a relevant factor under a disability insurance policy. 187. 3.7.2.1 Documents required. From a legal standpoint, a claimant must provide evidence to the insurer that a claim is valid. The production of such evidence obligates the insurer to pay the claim. The definitions of disabled vary considerably among different policies. Therefore, the documentation required to support a claim will need to match the benefit requirements stated in the insurance policy. The insurer will tell the claimant what it needs to assess a claim. Usually, the claimant must complete a statement and have their doctor provide an attending physician statement, APS. The doctor will be asked to state when the person's condition started. This is important because this insurance has a waiting or elimination period. The insurer may use the date given by the doctor to determine when the waiting period began. The person who may receive the disability payments can vary depending on who owns the policy and who has been named as beneficiary. Payments are made to the insured, which may be the life insured or another party, such as their employer. As noted, payment of a benefit will require proving the existence of a disability as defined in the insurance policy. The sequence is as follows. Black small square A period of total disability may be required before partial disability benefits are available. Black small square In this situation, the waiting period must elapse before benefits are payable. Black small square Proof the insured person is no longer able to perform the duties or activities of their occupation is required. Black small square Periodic assessment of whether the claimant is still disabled, and black small square Assessment that a claimant has recovered or not, and whether they remain permanently, totally, or partially disabled, if that situation is covered. Financial evidence may be required to support a claim for lost income and lost income potential due to a disability. 3.7.2.2 Medical and other examinations. Claims are based on medical evidence, from a family doctor or a specialist if required. There may also be additional medical evidence requested by the insurer, as they seek to better understand and verify the nature and extent of an individual's disability. Since claimants are expected to reasonably assist in their rehabilitation, the insurer may give them the opportunity to consult other specialists, which it will pay for. Critical illness insurance provides a lump sum payment should the insured become seriously ill. A claim is made if a licensed physician specializing in the determined illness diagnoses the insured with that illness or disease and it is covered by the insurance policy. Generally, a lump sum benefit payment will be made to the insured 30 days after the claim has been approved. Once the claim is paid, the critical illness insurance policy ceases. If the insured dies for a reason not covered by the critical illness policy, the premiums paid may be refunded to the named beneficiary. 3.8 Segregated funds and annuities. When the life insured under an annuity contract dies, the beneficiary or the estate is usually entitled to a death benefit. However, it is not the case when the annuity contract was an immediate life annuity contract that has begun to pay benefits to the annuity grantee that had no guarantee period, or with a guarantee period that has passed. Where a death benefit is owed by the insurer to the beneficiary or to the estate, our comments regarding the proof of claim under Section 3.1.4 apply. As discussed in Chapter 2, immediate or payout annuities may be purchased with a guarantee period. This means that if the person whose life is insured dies before the insurer has made a stipulated number of payments, the insurer remains obligated to continue payments. This is the guarantee. The annuity grantee, if not the same person as the annuitant, may receive the remaining payments, or in some cases, they may agree with the insurer to terminate the contract early and accept a commuted amount in the settlement of the policy. Now, amounts accrued in an annuity contract, segregated funds or GIAs, for pension purposes are generally referred to as locked in, as applicable legislation imposes important restrictions on the transfer of such amounts. Amounts accumulated in a pension plan may only be transferred in accordance with applicable legislation to the following. Black small square a lira. Black small square another pension plan. Black small square for the purchase of an immediate life annuity or a deferred life annuity. Black small square a LIF. 3.8.1 Death before retirement. When a person receives a pension under a pension plan and his or her spouse is also eligible under the same plan, if the person dies, the benefits will become payable to the spouse, even if the spouse was not the designated beneficiary. 188 The spouse may be able to roll it into his own locked-in plan. If there were no eligible spouse, the pension benefit will become payable to the named beneficiary. If there is no named beneficiary, the pension amount will be payable to the estate of the pensioner. 189. 3.8.2 Death after retirement. If the pensioner had an eligible spouse, the spouse may be entitled to a survivor's death benefit. Usually a reduced amount of the pension that was paid to the pensioner. 190 If there is no eligible spouse, a commuted lump sum representing the remaining payments in any applicable guarantee, if any, period will be payable to the named beneficiary. If there is no named beneficiary, it would be paid to the estate of the pensioner. One 88 Pension Benefit Standard. Chapter 4 Rules and Principles Governing the Activities of Life Insurance Agents and Accident and Sickness Insurance Agents. Competency Component. Black small square integrate into practice the rules governing the activities of life insurance agents. Competency Subcomponents. Black small square explain the role of the organizations that protect clients. Black small square integrate into practice the obligations and responsibilities of life insurance agents. Ethics and Professional Practice. 94 Chapter 4 Rules and Principles Governing the Activities of Life Insurance Agents and Accident and Sickness Insurance Agents. 4.